Hello friends, I welcome you all at Swayam platform. I Dr. Anup Kumar, Assistant Professor Faculty of Law, Banaras Hindu University. Friends, today we are going to enter in fourth week of our course. Here we are discussing about the Hindu personal law including marriage and succession. Friends, in the third week we discussed about the nature of Hindu marriage and condition of Hindu marriage. And we also discussed about the registration of Hindu marriage. Friends, we understand that Hindu marriage cannot be declared and understand as a contract. Why? Because we have a unique feature of marriage. Our social reality is totally different than Western reality. And in Hinduism, marriage is a distinct institution. Therefore, marriage is sacramental by nature under the Hindu law. Friends, we also discussed the condition of Hindu marriage with a special reference to section 5 of Hindu Marriage Act and section 7 of Hindu Marriage Act. Under section 5 of Hindu Marriage Act, we discuss about the monogamy, condition related with the mental capacity, condition on marital age. We also discuss about the prohibited degree relationship and Sapinda degree relationship. The law is very clear and simple in terms of condition, friends. Friends, we should focus on the marginal note of section 5, where section 5 provided that condition of Hindu marriage, not condition for valid Hindu marriage, means each and every conditions which are mentioned in section 5 have a different effect. Friends, neither party has a spouse living at the time of marriage. Person must be sound mind, capable of giving valid consent. Although capable, but if not able to understand the nature of marriage and unable to procreation, then also not capable for marriage. And age must be, the age of bride must be 18 years and bridegroom must be 21 years. They should not comes under the prohibited degree relationship, and they should also not comes under the Sapinda relationship, and their marriage must be performed as per the ceremonial rites and ceremony prevailing among them. Friends, these are the conditions. We also discussed the registration of Hindu marriage. So now I am going to discuss the fourth week, and under the fourth week the title is Hindu marriage law part 2, where we are focusing on restitution of conjugal rights, which is very unique remedy under the Hindu Marriage Act. So therefore, friends, in today's lecture we will focus on the restitution of conjugal rights. Friends, before starting anything, I want to discuss with you the learning objective of the today's class. We will discuss about the meaning and nature of restitution of conjugal rights. We also discuss the essential conditions of restitution of conjugal rights. We also discuss the constitutional validity of restitution of conjugal rights. We also discuss the concept of matrimonial home, and we also discuss the contemporary issues and challenges related with matrimonial home. Friends, we also discuss the effect of non-compliance of degree of restitution of conjugal rights under Hindu law. These are the learning objectives identified for the today's class. Friends, now I want to discuss first about the meaning and concept of restitution of conjugal rights. So friends, restitution means restorations, bringing back and reconciliation. Friends, conjugal right means the fulfillment of marital rights and obligation. Friends, after the marriage, every spouse have a right to cohabit and also a right to enjoy the society of others. Friends, husband and wife have both a right and duty to the society of each other. It is inherent in the very institution of marriage. Friends, this is the unique feature of conjugal relationship. There is no such rights and also duty in relationship of parents or brothers or sister. Friends, marriage is unique. The requirement of marriage is different. Rights and liabilities are different, and therefore cohabitation, society with each other is essentially required for the purpose of the institution of marriage. Therefore, restitution have a significant place in our legal system under the Hindu marriage law, friends. Friends, relationship of husband and wife may be broken by divorce, but as long as they are husband and wife of each other, have a duty not to withdraw from the society of others without good reason. Friends, after the marriage, husband is entitled of the society of his wife, and wife is also entitled to enjoy the society of her husband. Friends, before starting anything, we must also understand the nature of the restitution of conjugal rights. Friends, restitution of conjugal rights under section 9 of the Act is only positive relief under the Hindu Marriage Act. The objective of this remedy is to preserve the marriage. Friends, other remedies like the judicial separation, nullity, divorce, considered as a negative remedy. Why? Because they weakened the relationship bond between the parties, friends. Therefore, restitution of conjugal rights help to restore the missing link between the husband and wife. Therefore, this is unique as well as the positive remedy. Friends, because due to the restitution of conjugal rights, people may enjoy the fresh opportunity to the parties to make others, and they may live together by exercising the rights under section 9 of Hindu Marriage Act. Therefore, this is positive and this is not a negative remedy. Friends, now I want to focus on the bare provision of section 9. What section 9 actually provided, friends? So, we focus on the bare provision. When either the husband or the wife has without reasonable excuse withdraw from the society of others, the aggrieved party may apply by petition to the district courts for restitution of conjugal rights, and the courts, on being satisfied on the truth of the statement made in the such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. Now, this is the provision. As per the explanation, where a question arises whether there has been reasonable excuse for withdrawal from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. Friends, this is the point. On that basis, we are able to understand the restitution of conjugal rights. Friends, fundamental law is, after the marriage, either party of marriage bound to live together with other party of marriage. If without any reasonable excuse one party is not living with other party, which hamper the very nature of Hindu marriage, then a party may approach the court and approach may compel other party to live with the other party. Now the question is, friends, where we are living in individualistic society, whether section 9 is constitutional or not is a fundamental question. Because, friends, we are talking about the privacy, we are talking about the equality, liberty. Whether section 9 of Hindu Marriage Act able to qualify on different provision of constitutions which related with the privacy, equality and liberty. Therefore, the constitutional validity of restitution of conjugal rights must be explored. Friends, the constitutional validity of restitution of conjugal rights first time challenged in Andhra Pradesh High Court in T. Sarita versus Venkat Subbiah case. This is very interesting case in the Indian legal history, where unique arguments were raised before the High Court, and High Court finally declared Section 9 of Hindu Marriage Act as a null and void. Friends, first I want to focus on the fact of the case of T. Sarita. Sarita was a high school student, 16-year-old, and stayed with her parents in Madras. She married Venkat Subbiya on 13 December 1975. After the marrying, they were separated and had been living apart from each other for a period of 5 years. And after 5 years, husband filed a petition of restitution of conjugal rights before the district courts. The lower court, means district courts, passed the order in the favor of husband and directed Venkat Subbiya to live with husband. After the order of district courts, T. Sarita challenged the order of district courts before the High Court of Andhra Pradesh. And friends, what was argued before the Andhra Pradesh High Court? Friends, they argued that Section 9 is violative of Article 14, 19 and 21 of the Indian Constitution. Section 9 is a grossest violation of an individual right to privacy. Why? It denies the woman a full and free choice when and where and how her body was to become a vehicle of procreation. She further argued that Section 9 offends the guarantee of life, personal liberty, human dignity and decency. Friends, it denies the woman's free choice as and when and by whom the various parts of her body should be allowed to be served. She loses her control over her own intimate part of the body. Therefore, Section 9 is arbitrary. After the argument of T. Sarita, relying on these submission, the Andhra Pradesh High Court held that Section 9 of Hindu Marriage Act is constitutionally invalid and also declared that Section 9 unconstitutional. Friends, the first time in the Indian history, in a T. Sarita case, Supreme Court declared that Section 9 is unconstitutional. Friends, after the decision of the Andhra Pradesh High Court, the constitutional validity of Section 9 of Hindu Marriage Act, Restitution of Conjugal Rights, challenged in Harvinder Kaur versus Harvinder Singh before the Delhi High Court in the year 1984. And in this case, Justice A.B. Rohatgi held that the restitution of conjugal right is constitutionally valid, and the number of arguments raised before the High Court, and High Court also answered differently, but finally High Court concluded that Section 9 of Hindu Marriage Act is constitutionally valid. Friends, what High Court want to clarify in this case, the court cannot enforce sexual intercourse but only cohabitation. The objective of restitution decree is not to bring about the cohabitation between the estranged party so that they can live together in their matrimonial home in amity. Sexual intercourse is not a necessary condition of cohabitation. Cohabitation means the husband and wife living together as a husband and wife. The court held that in the husband petition under Section 9 seeks to inquire whether there is a reasonable excuse for the withdrawal by the wife from the society of husband or not. A spouse is entitled to the other society, and if the law enforce the conjugal duty, there is nothing wrong. The further High Court also observed that the leading idea of Section 9 is to preserve the marriage. Section 9 is an endeavor to bring about the reconciliation between the parties. Friends, in Harvinder Singh case, the Delhi High Court identified the purpose and also importance of the marriage institution. On that basis, High Court concluded that Section 9, Restitution of Conjugal Rights, is constitutionally valid under Section 9 of Hindu Marriage Act. Friends, the constitutional validity of Section 9 again raised before the Honorable Supreme Court in the case Saroj Rani versus Sudarshan Kumar, AIR 1984, Supreme Court, page number 1562. Friends, judgment was delivered by Justice Sabyasachi. What are the observation of the court in reference to Section 9 of Hindu Marriage Act? The Supreme Court held that the remedy of Section 9 is positive in nature. Section 9 protects the institution of marriage, and Section 9 is not compelling the unwilling party to cohabit. The non-compliance of the degree of restitution of conjugal rights for a period of 1 year of divorce under Section 13, 1 capital A, subclass 2 of the Act 1955. It means no one is compelling you. If there is no restitution after the decree of court, then obviously you may have option to proceed for divorce, not again for the restitution. Friends, on that basis, in the Saroj Rani case, the Supreme Court finally concluded that the purpose of Section 9 is to protect the institution of marriage and family. Marriage and family is crucial in our society. Therefore, this is not contrary to the rights of either husband or wife. It's have a clear objective to protect the marriage institutions. Therefore, this is constitutionally valid. The constitutionality of Section 9 of the Hindu Marriage Act has been challenged in the case recently by the Ojsa Pathak versus Union of India, 2009, by the PIL filed by a student of the Gujarat National Law University, Gandhinagar. This PIL was filed in the backdrop of Justice K.S. Puttaswamy case, because Justice K.S. Puttaswamy case let down the fundamental principle of privacy, where they declare that privacy is fundamental right. On that basis, now the question emerges that whether in the light of progressive interpretation of Supreme Court on right to privacy, whether Section 9 of Hindu Marriage Act is still vulnerable or may qualify the criteria of constitutionality. Friends, in this context, petitioner argued before the Supreme Court, and what their arguments? Their argument is consumer rights discriminatory to the women, because restitution have a feudal origin where they treating women as a property, and further they argued that cohabitation is an intimate personal choice. The right to live with and have a sexual relationship with someone is a personal right. So the framework's provisions to force a person to return to their house violates one's rights to privacy and personal freedom. So they argued in such way, therefore they claim that the restitution must be declared unconstitutional. Friends, so on the arguments basis, the Supreme Court may already identified certain issues. Do the provisions of restitution of conjugal rights violates the right to privacy and indivisible autonomy under Article 21? And second, do the provisions of restitution of conjugal rights violates the right to equality under the Article 14 by placing an additional burden on women? Friends, this is the arguments, and the case pending is before the Supreme Court, and final decision is yet to come in this case. Friends, before concluding my discussion on the constitutional validity of Section 9 of Hindu Marriage Act, I want to clarify you that you may select the argument of T. Sarita before the High Court that they focus on the dignity of a woman, privacy of a wife. But Supreme Court is very clear. If you are thinking about your right intimacy, right to privacy in bedroom, then every bedroom becomes the China Bazaar. The bedroom is beyond the domain of rights, because we have a private sphere of rights and public sphere of rights. Public sphere obviously may be regulated by the law, but private sphere is immune from the law. So therefore you cannot intervene in the domain of right to privacy. and you can't argue for the right to privacy. The purpose of section 9 is very clear, because section 9 want to protect the marriage, provides another chance to think over your stand. Therefore, on the basis of the constitutional arguments, no one can declare that section 9 is constitutionally valid. Therefore, so long as we are thinking that marriage have a importance in our social life, family also have importance in our cultural and social life, we can't argue that section 9 is unconstitutional. Lot of argument is going on. You may develop your argument and develop your conclusion in this context, friends. Then I want to focus on the essential condition of the conjugal rights, friends. For the purpose of remedy under section 9, essential conditions includes: the respondent has withdrawn from the society of the petitioner. Second, the withdrawal by the respondent party is without a reasonable excuse. And the third is, the court is satisfied the statement made in the petition are true. There is no legal ground for the refusing the grant of such decree. Withdrawal without reasonable excuse, the court is satisfied with your argument and there is no legal bar why court should not grant you relief. So friends, now I want to focus on the first point. The first point is, the respondent has withdrawn from the society of petitioner. Friends, the fundamental rule of the matrimonial law is that one spouse is entitled to the society and comfort of another spouse, and where a spouse has abandoned or withdrawal from the society of the other without reasonable excuse or just cause, the court should grant the decree of restitution. Now the question is, friends, what do you mean by society? Friends, the term society refers cohabitation, means living together as a husband and wife. Society also means spouses are fulfilling their matrimonial responsibility. The society means living together and fulfilling matrimonial responsibilities. And what is the meaning of withdrawal? Withdrawal means refusal to stay together, refusal to have marital intercourse, and refusal to give company and comfort. Friends, withdrawal involves mental separation as well as the physical separation, Friends, the act of temporary leaving matrimonial home would not amount the withdrawal from the society of others when there is no intention of withdrawal permanently. So this is the first condition, friends, withdrawal of society, Friends, now the second point is withdrawal from the society without reasonable excuse. So withdrawal without reasonable excuse is second condition for the remedy, Friends, Hindu Marriage Act does not define the idea of reasonable excuse. No one can reduce to a formula, and it would vary with time to time and circumstances of each case. It is a personal matter depending upon the likes and dislikes, grievances and sympathies, etc. The standard of reasonable man should be applied when you are thinking that whether there is a reasonable excuse for withdrawal or not. The test is whether a reasonable person would resort to withdrawal from the matrimonial home in the totality of the fact of the case or not. So withdrawal must be in reasonable excuse. So withdrawal without reasonable excuse is objectionable, then remedy may be seek against other party of marriage. Friends, then I want to summarize certain example which is declared by the court as a absence of reasonable excuse. For example, friends, there is a too much difference of age between the parties. This is not reasonable excuse to withdraw society. The respondent wife does not like the place of employment of the petitioner. The respondent wife accepted the job without the consent of the husband. The husband cannot provide the wife the comfort which she is being given by her parents in their home and can provide only within his means. The husband and his parents demanded dowry, but they did not ill-treated the wife. The suspicion about the character of petitioner is baseless. The husband is unemployed and wife is unable to adjust in the joint Hindu family. Apprehension of cruel treatment in future. So these are the examples of absence of reasonable excuse. If any party of marriage quoting these reasons withdrawing from the society, then the court is not going to provide any remedy under section 9 of the act. Now friends, example of reasonable excuse. It includes marriage was not solemnized accordance with the customary rites and ceremony. It is a reasonable excuse. Party have obtained divorce under the customary law. The respondent married the petitioner during the subsistence of the former first marriage. The petitioner is guilty of persistent neglect. The petitioner is guilty of beating and ill treatment even if it does not amount to legal cruelty. The marriage is annulled under section 12. The husband was living with the widow of his brother. The petitioner is living with a concubine. The fraud was practiced upon her to obtain her consent. The petitioner is himself guilty of deserting the respondent, and the petitioner is committed adultery. The petitioner is wanted the wife to earn money by prostitution. These are the reasonable excuse for withdrawal of society. If the marriage is not solemnized properly, if you are compelling for prostitution, if you are using force against the either party of marriage, these are the conditions where reasonable excuse exists for withdrawal. And if a person by quoting reasonable excuse withdraw your society, then you cannot compel other party to live together. So friends, when you are going to understand the idea of reasonable excuse, the cluster of cases where the court declared that these are the examples which is absence of reasonable excuse, and these are the set of examples which talks about the presence of reasonable excuse. The withdrawal in absence of reasonable excuse provides ground to the court to pass order against a party, but withdrawal due to reasonable excuse, the court cannot pass any order against a party of marriage. Friends, now the important point is, friends, withdraw from where? Friends, after the marriage, people, husband and wife living together. Therefore, friends, the courts developed the idea of matrimonial home in India. The matrimonial home is the primary residence where a married couple reside during their marriage. Friends, the place where both the husband and wife share the house of each other as a life partner. The expression matrimonial home is used. Friends, the expression matrimonial home is not used under section 9 of Hindu Marriage Act. The term conjugal society and matrimonial home are often used interchangeably and as synonyms by the court. Friends, matrimonial home means after the married husband and wife sharing a place. Generally, it is a place of husband or husband's parents, or as the case may be. Both the parties should live at matrimonial home after the marriage as per the legal requirement, friends. If a person is not living matrimonial home, it may be treated as the withdrawal from the society by others. Friends, the concept of matrimonial home may also be explained and understood on the basis of the Protection of Women from Domestic Violence Act. Under section 2, yes, the Domestic Violence Act also explains the idea of shared household. And the idea of shared household that is defined in the Domestic Violence Act may be useful for the purpose of understanding the restitution of conjugal rights, friends. Therefore, the shared household may be equivalent to the matrimonial home, friends. Friends, now the concept of matrimonial home. Now the fundamental question is, who has the competence to determine this matrimonial home, whether husband or the wife? Friends, traditionally husband had the right to determine, not as a privilege granted by the traditional Hindu law, but because he was legally obligated to maintain his wife under section 18 of Hindu Adoption and Maintenance Act 1956. Therefore, they have also right to determine the matrimonial home. Friends, Hindu Adoption and Maintenance Act 1956 under section 18, maintenance of the wife, subject to the provision of this section, a Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained by her husband during her lifetime. The point is very clear. Husband is under the obligations to maintain wife. Wife have no such kind of obligations. Therefore, the privilege of matrimonial home given to the husband, because they are also bound, legally bound to maintain her wife, friends. So therefore, they may determine the matrimonial home. But friends, the different kind of argument is there. The wife has no corresponding legal obligations to maintain her husband. Should the husband's mere obligations to maintain his wife be the sole determining factors in deciding the matrimonial home? Friends, the wife also bears significant responsibilities, and it is difficult to determine whether the set of duties are more challenging. Both spouses have crucial role in respective sphere, and these responsibilities deserve mutual respect. Therefore, no one can say that one person may arbitrarily define the matrimonial home. Therefore, friends, due to the present economic and cultural challenge, we are bound to think about the idea of matrimonial home, friends. In a case of employment, how we can determine the idea of matrimonial home? Friends, where the wife accepts the employment with the consent of husband, whether due to the need or due to the greed, in such circumstances, the separate living of wife is not a withdrawal of a reasonable excuse. Not a withdrawal without reasonable excuse. However, if the husband later withdraw his consent and wife refuse to return, husband cannot give arbitrary power to determine the return of his wife. He must show reasonable cause for asking the wife to resign her job and return. Husband may have to prove a basic and substantial change in the circumstances. If there is no such cause, the wife has good reason to leave away from the husband. Or in such cases, the spouse may visit each other in their convenience. In such a case, two matrimonial home would be there. Friends, the second context is, wife may be implied before the marriage. So in these circumstances, there must be a pre-marriage agreement according to the public policy. Therefore, a question is, what is public policy? So no one absolutely prohibits other parties. This is the public policy. In a case of pre-act marriage employment, wife is free to live separately, because I hope the parties are aware about this fact. Friends, the next condition is, the wife may take up employment either because of husband's incomes is insufficient to meet the household expenses, or because she is afraid of losing support from her husband. If the husband prevents the wife from visiting him at reasonable time, it may amount to withdrawal without reasonable excuse on his part. The next scenario is, if the wife takes up employment without the husband's consent, without any fear of losing maintenance, without a noble social purpose, or get herself transferred without valid reason or provocation, it may be considered an unreasonable withdrawal from the society of her husband. If the husband is unemployed and the wife is working, she refused to resign from her job, cannot be considered an unreasonable withdrawal from the society of her husband. Friends, therefore in that context we will decide matrimonial home, and idea of matrimonial home may be flexible in this context, friends. Now the third essential requirement is truthfulness of the statement in the petition. The court must be satisfied that the statement given in the petition are true. For example, a case Vijay Dow versus Srimati Alka Dow. In Calcutta High Court, her husband himself took his wife to the mother's place for confinement. This does not amount to withdrawal from the society, and court observed the petition is not true. In one side you confine the wife and claiming that we need remedy under section 9. This is not allowed, friends. Friends, it is the basic principle of judicial process itself that the party has to prove what he states. The court is not concerned with the general truthfulness of the petitioner. It has only to see whether matrimonial rights is violated or not, giving statutory rights of filing a petition of restitution of conjugal rights. Friends, now the fourth essential requirement for the restitution of conjugal rights, absence of other legal bar. The petitioner intended to seek advantage of his own wrong or disability, where an undue delay in the institution of proceeding, a legal bar may arise under the substantive and procedural law where you could not allow for this remedy, friends. For example, section 18 subclass 2, where wife have a right to live separate and claim maintenance. Wife living separately and claiming maintenance, this cannot be treated as a withdrawal, and the court is not going to provide any kind of remedy under section 9 if a order has been passed by any court under section 18 subclass 2 of Hindu Adoption and Maintenance Act. Friends, it is not possible to visualize a priori all bars which any provisions in the vast ocean of the law. Friends, now the point is, friends, suppose a person prove a case under section 9, then what will happen? Whether court have a discretion? Friends, because section 9 use terminology may pass a decree, court may pass a decree, may decree restitution of conjugal rights accordingly. The question is, friends, whether court may means whether court may be, may not be. But friends, as per the provision of section 23 class 1 class E, if there is no legal ground why relief should not be granted, then and in such case but not otherwise, the court shall decree such relief accordingly. This suggests the court is bound to grant relief. The rule laid down by 23(1)(e) will prevail therefore, and these circumstances where the case is proved, then court is bound to pass the decree under section 9. The court may decree must be read as court shall decree because of section 23(1)(e) of Hindu Marriage Act. Friends, effect of non-compliance lead execution of restitution of conjugal rights, and executions rule provided in order 21 rule 33 of CPC, where the decree will be executed by attaching the property. By attaching the property only, there is no provision of civil imprisonment shall be given to the party. Friends, why not civil imprisonment? Because they want to live together. Civil imprisonment is not a reasonable way. If you confine a person, means you are also restricting to them to cohabit with each other. Friends, this also become a ground of divorce. If after the expiry of 1 year there is no cohabitation, then it may be used as a ground for divorce, and divorce decree may be granted to the party. Friends, as I discussed with you that restitution of conjugal rights decree may have a relation with divorce. It may be converted as a ground for the divorce, and simultaneously, friends, and the petition under section 9 mutually may be converted divorce by mutual consent. Friends, now the question is, friends, should the remedy of restitution of conjugal rights be abolished or not? Friends, in England, Matrimonial Proceeding and Property Act 1970, the remedy of restitution of conjugal rights is abolished. The argument in the support of abolition is the provision is generally misused. For example, the party generally comes to the court for this remedy not with the motive to get his or her spouse back, but in order to defeat a petition by him or her for maintenance. The marriage is a matter of emotional bond, and if a person does not want to cohabit with another, then decree of restriction of conjugal rights is an interference of his or her personal matter, compelling him or her to do. Therefore, it should be abolished, because you cannot compel a person to live together and cohabit with each other. Emotional bonds cannot be enforced by the court. Then why you are continuing with the court? But friends, certain arguments also given in the support of restitution, where debtor argued that restriction of conjugal rights has little practical utility yet in India. Friends, Indian peoples are emotional, they are less educated. Sometimes people break emotions. Therefore, it provides an opportunity, an alternative to think over the drastic step, and therefore it is a facilitative to save the marriage and rethink over the decision. Therefore, it is useful. And therefore, friends, so long as we are thinking the marriage and family is important, we should continue with section 9 of Hindu Marriage Act. And friends, in the light of entire discussion, we may think about certain point. Friends, how did the concept of matrimonial home undergo a gradual change in the light of judicial interpretation? Second, what is the constitutional validity of section 9 after Justice K.S. Puttaswamy judgments? The cohabitation is an intimate personal rights of an individual. How far it is infringed by section 9? Friends, by this discussion, I want to conclude my today's observations about section 9, restitution of conjugal rights. Friends, 4 important conditions are relevant in order to obtain relief under section 9. A party withdrawal of society without reasonable excuse, truthfulness of statement, and there is no legal bar, then court shall pass the decree under section 9. This remedy is constitutionally valid because argument raised by the T. Sarita was neutralized by Supreme Court in Saroj Rani case by highlighting the importance of marriage in our life. And recently in 2025, 12 April, Justice Nagaratna also identified that family is a fundamental of the Indian society. And the purpose of section 9 is to protect family and marriage, and it is not against the rights of either party of marriage. Therefore, it should not be declared constitutionally invalid. And therefore, friends, this is constitutionally valid rights, friends. Friends, the fundamental point is matrimonial home. Matrimonial home means generally husband's home or husband's father home. But due to the socio-economic change, due to the employment, now a common place may exist as a matrimonial home. Maybe a common flat, common place of business, or a place of employment where a party may easily access the place. Friends, but when the court is going to pass an decree under section 9, the court obviously bound to recognize and identify whether reasonable cause exists or not. If withdrawal is without reasonable excuse, decree may pass. If reasonable excuses exist, for example, friends, in certain circumstances, wife is entitled to live separate because of the bad behavior of the husband under section 18 subclass 2 of Adoption and Maintenance Act. Is a reasonable excuse, then the court will not pass any kind of order. Friends, the decree may be executed under order 21 rule 33 for forfeiture of the property, but there is no provision of civil arrest, and if the decree is not in consummation is not started after 1 year, it may become the ground of divorce. Friends, this is all about the restitution of conjugal rights. Thank you for your patience. Thank you, friends. Thank you.